Let's look at some other defenses, the specific excuse defenses. There are 4: infancy, intoxication, ignorance, and mistake. So let's jump into infancy. Basically what that means is too young, a defendant's too young to commit a crime. The actual defense of infancy is not used at all, I don't think, anymore. And the reason being is if you're sitting, just visualize how this defense works. You're at trial and the defendant is trying to raise the issue. Oh, I'm too young to commit a crime. The modern view is it's set forth in a statute of what constitutes infancy, meaning how old are you when you develop the ability to have intent to commit a crime. But under this defense, the defendant's not subject to criminal prosecution because they're too young to commit the crime. Why is that? The understanding is these defendants or children are too young or too immature, like I said, to form the criminal intent. So what age does criminal intent form? The feds say 11, and states differ on what constitutes too young to commit a crime. Our court here in New York, we have a juvenile court, which is the branch of the family court. It's not a criminal court. And the purpose of juvenile court is to rehabilitate. You want to keep young people out of the system. If we prosecuted 11-year-olds, there's a very good chance, if you've taken criminology or maybe you touched on it in Introduction to Criminal Justice, there's a good chance that they would continue to commit crimes throughout their lifetime. Under the Model Penal Code, actually before we get to the Model Penal Code, I want to tell you what our age groups are. Age groups under the age of 7, if a 6-year-old up to their 7th birthday commits a crime, it won't constitute a crime. They're incapable of forming criminal intent. If the individual is between the age of 7 and their 14th birthday, there is a rebuttable presumption that they lack mental capacity to form criminal intent. And what do I mean by that? Remember that whole presumption? There is a presumption that between those ages, they can't form criminal intent. However, that presumption can be overcome with evidence. The evidence, in these situations, what's looked at to determine whether intent could be formed is what's the nature of the offense, the sophistication of the offense, any criminal history, like the background of the individual, the threat that the individual poses to public safety. All of those things are taken into consideration. I'm just going to pose this, but visualize a 12-year-old going into the convenience store with a parent, and the parent's paying. Let's say they pumped gas at the gas pump, and they have to come in and pay. And they're paying, and in the meantime, while they're paying, the 12-year-old's in the candy aisle sticking candy in their pocket. Do you think that should be looked at as a crime? Should they be charged as a crime? And I'm just leaving it there for you to think about. And at the age of 14, you can be charged as an adult. And these are the general ranges. The youngest person to ever be tried as an adult, and like I said, this varies from state to state. Before I tell you who the youngest person is to be tried as adult and held responsible, there are 13 states that have no minimum age for adult prosecution of children, by the way, and Florida is one of them, which is where Lionel Tate, who was 13 years old, got a life in prison sentence for killing his young friend who I believe was 7, a neighbor friend who was 7. He was reenacting WWE moves on the, it was a young girl. So if you want to find out more, you can Google Lionel Tate. New York State. Let me give you a little background on New York State. They've made some changes to the ages with regards to children. It used to be you could be convicted of a crime between, if you were 16, 17, or 18. Up until your 19th birthday, they treated you as something called a youthful offender, but you still got tried in criminal court. Just that this youthful offender component was, if there was a conviction found, the judge can seal your sentence, so you wouldn't have a criminal record between those ages. But recently, October 2018, New York, and by the way, North Carolina was the only other state that allowed for prosecution of 16, 17, and 18-year-olds without having to overcome a presumption. They just got arrested and go to court and be treated like everybody else who's an adult there. Now they have what's called the youth. North Carolina was the same, and they're still the same, but New York now has developed a youth court for those individuals who are 16, 17, and 18, and that allows for them to not have to go through the criminal court process, which, by the way, is an open public forum and can be viewed. Juvenile court and youth court are not, so it's under seal, and so it's not open to the public. And we still have a juvenile delinquency court for folks between 12 and 15. However, if there's that rebuttable presumption, if the district attorney's office, prosecutors want to try somebody in that age category ranging from 12 to their 19th birthday, they have to make a special application to the family court and request that the child, the youngster, be tried as an adult, and they have a lot of hoops to go through to get there. And the model penal code, their rule: a person can't be tried or convicted of an offense at the time. It looks like there's a typo. Convicted of an offense at the time of the offense he was less than 16 years old. So 16 and older under the model penal code, whatever state has that, which I'm going to guess is North Carolina, based on what I've already told you, you can be tried as an adult. So back to what happens if a 14-year-old steals candy from a store? If you are in the model penal code, there's probably some family court or juvenile court that person will go to. I doubt that a prosecutor will go through the efforts to make an example of the 14-year-old and prosecute it in adult court. The 12-year-old would be in juvenile court as well, that example that I had earlier. The question is, do you think that they can form intent? They know they're stealing candy? I'll let you think about that. Oh, I already told you about juvenile court and youth court, and can a juvenile ever be prosecuted as an adult? Yes, the people have to make a special application. Youth court exists, as far as I know. This is unique to New York relative to a youth court, and juvenile court is for folks who are 15 up to their 16th birthday, 12 and up to their 16th birthday. And that's a branch of the family court. I don't know if you guys recognize this scene. Slenderman, who was a kind of an internet story that seemed to attract young children. And this involved, there was a case that involved 2 young girls. They were 12, I think, at the time, 12 and 13. They attacked their friend who was also 12. they're very young, and they might have been 13, 14, 12, but they're underage. And what happened was the two girls brought their other friend out to a wooded area and began stabbing her to death. I think she suffered like 19 knife wounds, and left her there. And she was found. She was alive. Didn't kill her. And she said what happened, who attacked them, and these two girls were arrested. And the people wanted to try them as adults, and I believe they were able to convince the court to try them as adults. And this case went on for a number of years. There was a lot of there's a documentary on it that HBO did. If you're interested, you can Google the Slenderman case, involving the two girls who tried to kill their friend. But in the end, they were in adult court. The case never went to trial. And what happened was there was a finding or an admission, an agreement between everybody that both girls had suffered from a mental defect. So it was kind of like an agreement to insanity. And one of the girls is in a facility. Actually, I think both of the girls are in a facility. One is supposed to be there for quite a long time, without being able to get out with evaluation. There's a period of time she has to stay there, but I believe in the end she was diagnosed and had been suffering from schizophrenia, and the other young girl as well. So this kind of ties in our infancy, the taking a young individual into the adult court, and then having, let's call it the insanity defense, even though they didn't have to use it at trial. It was certainly used. And if you're interested, it's very fascinating. There's a documentary. It's on HBO, but I also think you can stream it on one of the apps for a small fee. So intoxication is our other excuse. Is that an excuse? I'm intoxicated, so I shouldn't be charged with a crime. What this does is focus on the defendant's ability to form criminal intent. It's when you are so under the influence, you don't know what you're actually doing. It's kind of a level of insanity, but not with a mental defect. You just don't know what you're doing. Can you get that so intoxicated you don't know what you're doing? And do you think it should be a defense to a crime? Should being intoxicated absolve you of responsibility of committing a crime? Oops, I did not mean to kick that ahead. I want to continue to talk about intoxication for one more moment. The Model Penal Code has a definition: a disturbance of mental and physical capabilities resulting from the introduction of substances into the body. Okay, that's a definition that they give for intoxication. And we can agree that you can become intoxicated involuntarily or voluntarily. And there should be a difference in criminal responsibility. So let's talk about this voluntary intoxication and how it works. Basically what it does is it negates the intent. Okay, the intent element. If you have a crime that says you intend, a defendant is guilty of blah, 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 if they intend to, or if they do something intentional, that's what it does. It negates the intent. So if you're so intoxicated that you're prevented from forming that criminal intent, you're not going to have liability. But what about the charge of recklessness? Remember our definition of that? Our two-pronged test? That's kind of not going to work for you. It's not going to, because you don't have to have some level of forming something in your brain. You just have to act in a certain way. But you could end up with a reduced liability as well, because there are some where you don't need the intent. I actually there are a lot of cases that I've had that I've gone to trial with a defendant, and alcohol is involved, and every single time I can get information out of the witnesses that my client, the defendant, was drinking, he was obnoxious, all of those things that come with being intoxicated. And when you ask the judge to tell the jury like what instructions should be read, I ask for, judge, you have to give me instruction that my client was intoxicated. That's a requirement if I put evidence out there that the judge would have to grant for me, for the jury to decide whether or not my client was so intoxicated that he couldn't form the level of intent. Yeah, juries don't particularly like that defense. They just kind of blow right on over that. I have yet to win on that. And when I get to talk to the juries after the fact, I always ask them. I go, but he was drinking. They went, psh, whatever. Like, they just blow me off. That makes no difference. I have some say that makes no difference in our decision. They don't like, the idea if you're voluntarily intoxicated and then you go to your ex's house and start banging on the door. That's just not gonna fly. But involuntary intoxication, you got a better shot. Why? Because you didn't know you ingested probably a drug. That's how that works. Or, it could be somebody slips you a drug, you didn't know you were taking, but also you could be on a new medication and there's this side effect that, makes you go into a hypnotic state. If you don't know about it, it's not your doing, then that's going to get you a better chance at intoxication. Model Penal Code, intoxication, which is not self-induced, is an affirmative defense if by reason of such intoxication the actor at the time of his conduct lacks substantial capacity, either to appreciate its criminality, i.e. the wrongfulness, or to conform his conduct to the requirements of the law. So certainly it's recognized as a defense both ways. Florida does not recognize this as a defense. It does specifically state that it will negate the element of a criminal intent only if we're dealing with a prescribed drug. If you're under the influence of an illegal substance or alcohol, it's not a defense in the state of Florida. So switching gears to ignorance and mistake. Is it a defense to say, I didn't know that was illegal? I didn't know running a red light was illegal. I didn't know taking that candy from the candy store was illegal. I hope you are saying, no, that is not a defense. Ignorance of the law is not a defense, but mistake of law could be, as well as a mistake of fact. So let's kind of distinguish between mistake of law and mistake of fact. Mistake of law, what it is. The gist is that the defendant believes his or her conduct is illegal. Okay? They don't know that it is not the law. But that doesn't mean, oh, I didn't know that was illegal. Ignorance and mistake are different. And the Model Penal Code says, mistake as to a matter of fact or law is a defense if the ignorance or mistake negates the purpose, knowledge, belief, the recklessness, or negligence required. See, they actually spelled them all out. It's the criminal intent required to establish a material element of the offense, or B, the law provides that the state of mind established by such mistake constitutes a defense. Let's kind of break it down. This is my definition of mistake of law. Reasonably rely on a statement of law and it's later deemed invalid. Okay, mistake of law. Belief that conduct does not legally constitute an offense. The actor must act in a reasonable reliance upon an official statement of law, afterward deemed to be invalid, contained in a statute or judicial decision. So it could be changed by a statute or by a court, or when a statute or other enactment defining the offense is not known to the actor or hasn't been published. So basically, there's no reasonable notice of the law. You cannot say I didn't know it was illegal. But if you reasonably rely on a statement of law and it is later deemed invalid or wrong, you can't be held responsible upon relying on it. Okay? So if you learn no law in place for certain conduct, and I think I actually have a example. I thought I had an example. It's the example that's in the book. That's the one I want to go over here. But let me finish my thought on this. So basically, there's no, if you have no reasonable notice of the law, you can't say you didn't know it wasn't illegal. But if you reasonably rely on a statement of law and it is later deemed invalid or wrong, you can't be held responsible upon relying on it. Okay? Like those ex post facto laws we talked about, you can't be punished retroactively. So let's take our one in the book, because it's a really good one, with our attorney friend. I wish they had page numbers in the book, but they don't. Shelby, an attorney, researches current case law and determines that it is legal to sell products over the internet and not charge sales tax. Okay? So Shelby starts selling designer clothing on eBay and does not charge her customers any sales tax. The case decision that Shelby relied on is now overturned by the court, a higher court, and Shelby can probably assert a mistake of law as a defense to the crime of evading payment of sales tax if in the event that Shelby is charged. However, even though there's an attorney in that example, if you rely on bad attorney advice, but my attorney told me that wasn't illegal, guess what? That's not a defense. Unfortunately, I know you're relying on an expert to give you law, but relying on bad advice from an attorney is not a defense. Mistake of law is very, very rarely used, but it's there and it exists. Mistake of fact is a more likely defense that happens, and which, by the way, I want to give you some examples of, or just break down that mistake of law. So these are the things you're looking for. The law's not published, you're not on notice. When you relied upon a statute that was later overturned or held, that's not going to, you can't be charged. When you relied upon a judicial decision, when you relied upon an interpretation by an appropriate official, no. Okay? When you relied upon a judicial decision that you misread, it's probably not going to be a mistake of law either. So you want to be extremely careful on this. This whole ignorance, I didn't know, it's going to be very hard to say one way or the other when it's out there. But the example, because that example that's in the book actually happened in real life, and that would be a good example of mistake of law. But like I said, mistake of fact is more likely the defense you'll see. And what is mistake of fact? Facts as the defendant believes them negates the intent. That's the little shortened version of it. If the facts of a situation as the defendant believes them to be negates the requisite intent for the crime at issue, the defendant can assert a mistake of fact. Let's start with a simple example. Mark is in a popular restaurant and he's sitting at a table with Julie. He bends over, he picks up a briefcase that he thinks is his, but it's actually Julie's, and he walks off. Is there a crime? No, that's considered a mistake of fact. He believed it was his. Same thing with the example from the book. Mike sees Rachel riding his bike in her driveway. He walks up to her and demands she gets off his bike and return it to his garage. She's scared, jumps off the bike, leaves it in the driveway and runs inside. Mike picks up the bike and brings it back to his garage, but lo and behold, there is his bike, right? The same type in his garage. He can argue mistake of fact. How about John gives Mark a baggie and tells him it's cocaine and instructs him to bring it to Sandy in exchange for $1,000. Mark does so, but Sandy is a CI, confidential informant, and Mark is arrested for selling drugs. The substance turns out, when it's tested in a lab, the substance turns out to be candle wax and not cocaine. Is this a mistake of fact? Can Mark assert mistake of fact? He actually cannot, because he thought it was cocaine. Now, the charge might not be selling a controlled substance. It might be attempted selling a controlled substance, and we'll talk about attempted in a couple weeks. But the point is, this is not a mistake of fact, because John tells him it's cocaine and instructs him to do what he needs to do, get it to Sandy in exchange for $1,000, and he does just that. He thinks he's selling Sandy cocaine. Not a mistake of fact. Mark works at a bakery. John tells him to deliver a bag of flour sitting on the table to Darcy's bakery in the next town and charge $50. Mark does so. Darcy goes to bake cupcakes an hour later, but the flour looks weird to her. And she kind of takes a smell of it. She's troubled, so she calls her police officer husband to come check it out. Sure enough, it is cocaine. Mark is arrested for selling cocaine. Does he have any defense? He does, because he thought it was flour. He works at a bakery. John tells him to deliver a bag of flour. Someone's going to get in trouble for it, but it's not going to be Mark. Like, where did it come from? He didn't know. It might be actually, I mean, the people are going to have to show that he intended to sell cocaine. So this is a mistake of fact. You're stopped for speeding, doing 85 and a 65 down the interstate. You're stopped and you are issued a ticket and have to be in court. At court, you tell the judge, I didn't know I was speeding, and my speedometer was broken. Do we have a defense? Any sort of mistake of law, mistake of fact? I didn't know, right? Doesn't matter if you don't. It doesn't matter if you don't know what the law is. You do know that speeding is illegal. You just don't know what your speed is. Is that a mistake of fact? No, it is not. And not because we're negating some intent, but this is a strict liability crime. We talked about this. You don't need intent. You just need to be speeding, and the people just need to prove that you were speeding on the interstate. That you were going above 65 miles an hour on the interstate. You don't need to intend one way or the other. So that was just kind of, number one, it's kind of a trick question. But number two, it leads me into my next topic, which is entrapment. And if we were in a classroom, I would ask, how many of you think when the cops have a little speed trap, think it's entrapment? And I see some hands that go up, but that is not entrapment. What is entrapment is when the government induces an individual to commit a crime. Nobody's inducing you to speed down the highway. They just happen to be sitting there with their radar gun, and they catch you speeding down the highway. But entrapment is government uses inappropriate, persuasive tactics when apprehending criminals. That does not mean that they cannot put bait out there, though, okay? They do it all the time. They pose as prostitutes, right? Officers in bars. When John approaches and propositions, then you have a crime that's been committed. You don't have entrapment. They can just put the bait out there. Nowadays, be careful. Phony ads on Craigslist exist, and there's a series of ads, and I hope you guys don't look at these ads, but there's a series of ads that hit Facebook. Things like lonely 15-year-old looking for an older man for a good time, things of that nature. Those are lots of times they're real and they're illegal, but lots of times there are also the police putting them out there. And if a adult approaches, a young person we've already talked about that with statutory crimes, or the statutory rape being an example with regards to the minor. The police put those out there. They'll put ads out there waiting for people to answer them, and when they show up, oh, look, it's the police. So they can set bait. The government, the police, they can set bait. Entrapment, however, they cannot do. We're going to break that down with some examples. It is an affirmative defense, and if successfully proven, the defendant is acquitted. They can get out of the crime they were charged with. There's no reduction. It's just, oops, the government, but before it had not only used the word force, but the government is the one by inappropriate tactics that got the individual to commit the crime. There is a test. It's a two-part test for entrapment. There's a subjective and an objective. And the majority of the states and the feds use the subjective test. The Model Penal Code and other states have an objective test. So we're going to break these two down and look at them both. Before we move forward with the examples, I just want to say that the reason why we have entrapment as a defense, the whole purpose behind this defense was to prevent law enforcement, our government agents, from encouraging crimes in order to apprehend persons wanted for criminal acts. And the key we got to look out for here is whether the person who ultimately committed the crime was inclined to commit the crime or did so only because the agent induced it. Okay? Back to the prostitute in the bar. It's an undercover agent. She's sitting there at the bar, and the John comes up and has a drink, and they start talking, and she becomes super flirty, because that's what would happen if it was not a setup. Putting herself out there as being available and so forth. That's setting the bait. Okay, like, it's focusing on the defendant's characteristics. In this case, the John. Was the defendant predisposed to commit the crime already? But you got to watch. But looking at the agent's behavior, you have to look: are there threats? Are there harassment? Is there fraud? Is there flattery to induced? What kind of tactics are they engaging into? Okay, so that's what we have to look at. And I like to use this entrapment versus opportunity, because law enforcement can give opportunity. They just can't step over the line. Okay? So where am I going? Another example. So I want to just hit home the key aspect of this entrapment, because this can be somewhat of a gray area. Okay? The government, I can't stress enough, the government agents do not entrap a defendant simply by offering them, right, an opportunity to commit a crime. The judges expect people to resist temptation, ordinary temptation to violate law, okay? An entrapment defense arises when the government agents resort to let's call it repugnant behavior. And some of those that I gave you before are examples: harassment, fraud, over flattery. Now let's break this down with some examples. So Mary Ann Berry is charged with selling illegal drugs to an undercover police officer. Berry testifies that the drugs were for her personal use, and that the reason she sold some to the officer is that at a party, the officer falsely said that she wanted some drugs for her mom, who was in a lot of pain. According to Berry, the officer even assured Berry that she wasn't a cop and wasn't setting Berry up. Do we have entrapment here based on what I've just said? So we have Mary Ann. She's at a party. There's an undercover officer there at the party who approaches her about having some drugs. And she says to Marianne, yeah, I need some drugs. My mom is in a lot of pain. Sell me some drugs. Believe me, I'm not a cop. I'm not a cop. I'm not here to set you up. And Marianne sells her drugs. Is that opportunity? Or is that entrapment? She lied. She lied about not being a cop and not setting her up. And she probably lied about her mom too. On the drugs. This is probably just a story. Entrapment. This is not entrapment. The police can certainly lie. They do it all the time. But does this go beyond lying? Is this, resist? Like I said, think about it. The courts expect people to resist any ordinary temptation. Is this a temptation? Marianne might think, I can make a few bucks. Is this, such threats and harassment, fraud, over flattery? No, this here is not entrapment. This would be opportunity. Let's say Marianne Barry is charged again, selling illegal drugs to an undercover police officer. Barry testifies that the drugs were for her personal use. For nearly 2 weeks, the undercover officer stopped by her apartment. This is her testifying. Would stop by my apartment and pleaded with me to sell her some of my stash because her mom was extremely sick and needed the drugs for her pain relief. I kept refusing. When the officer told me that the drugs would allow her mom to be comfortable for a few days, the few days she had to live, I broke down and sold her some of my drugs. She immediately arrested me. Does this constitute entrapment? She does this for 2 weeks. If this was just one encounter, I think we'd have opportunity. But we have 2 weeks, and now we have continued lies over the 2 weeks. She may be repeating the same lies, but we're going day after day after day. The repeated, attempts. This is more likely entrapment. Okay? See the difference between the two? I think there's a pretty good example in the book, too, that goes through entrapment. You can look through that one. And immunity, I'm just putting it out here. It's a release from prosecution. The only people who can give a defendant, it's not really a defense, but you have to know it's kind of out here, immunity. Only a prosecutor can grant a defendant immunity, and normally that comes along with conditions. We will dismiss all the charges against you and grant you immunity if you testify against all of these other people. Right? That's how that works. This isn't, I'll give you a plea deal, a lesser charge and no jail time if you do A, B, and C. That happens too. But immunity is you cannot be charged for the crimes that they want to charge you with in exchange for you helping, or defendant helping or doing something for the prosecution. Okay? And that is defenses. We covered a lot of defenses in the last couple weeks. We're going to move on from here.